You're about to make one of the biggest financial mistakes of your life, and you don't even know it yet. You survived a divorce. You rebuilt your life. Maybe you found someone new, someone who makes you feel like yourself again, and now you're thinking about walking down that aisle one more time. That's beautiful. That's hopeful. But here's the cold, hard truth that nobody is telling you at the rehearsal dinner. Remarrying without protecting these 3 specific assets could wipe out everything you spent decades building. I'm not talking about losing a little money. I'm talking about your retirement account, your home, your inheritance for your kids. All of it. Potentially gone. And in 2026, with new financial rules and updated estate laws changing the game, the risk is higher than it's ever been. So before you say, I do again, stay with me, because what I'm about to share could literally save your financial future. Welcome back to James Retires. If you're new here, this channel is all about helping people in their 50s, 60s, and beyond make smart, confident financial decisions, especially during life's biggest transitions. And if you've been watching for a while, you already know we don't sugarcoat anything here. We give you the real talk that your financial advisor might be too polite to say. So if that's the kind of content you want in your life, hit that like button right now and subscribe, because we drop new videos every week and you do not want to miss what's coming. Now, let's get into it. Let's talk about remarriage and money, because this is a conversation most couples completely avoid. Nobody wants to bring up prenups at a romantic dinner. Nobody wants to talk about estate plans when you're excited about flower arrangements and venue deposits. But here's the thing. Financial problems are the number one reason second marriages fail. Not lack of love, not incompatibility, money. Specifically, money that wasn't protected, wasn't discussed, and wasn't legally secured before the wedding. And the 3 assets we're going to talk about today are the ones that show up again and again in divorce attorney offices and probate courts across America. These are the assets people wish they had protected before they remarried. Let's start with the first one, and this one surprises a lot of people. Your retirement accounts, your 401k, your IRA, your pension. Most people assume these are automatically protected because they're in your name. That feels logical. You earned that money. You contributed to it over 30 or 40 years. Surely your new spouse can't touch it, right? Wrong. In most states, if you don't update your beneficiary designations before or immediately after remarrying, your new spouse could end up with legal claim to a significant portion of those funds. And here's where it gets even more complicated. Let's say you never updated your beneficiary form from your first marriage. That means your ex-spouse's name might still be sitting on that account. If you pass away tomorrow, guess who gets the money? Not your new partner, not your kids, your ex. The law doesn't care about your intentions. It only cares about the paperwork. This happens more than you'd think. And families find out after it's too late to do anything about it. So the very first thing you need to do, before the invitations go out, before the venue is booked, before anything, is pull out every single retirement account statement and look at the beneficiary designation, then make an appointment with a financial planner and update everything with clear, legally documented intent. Now here's another layer to the retirement account issue that most people never think about. In states that follow community property laws, and there are 9 of them, including California, Texas, and Arizona, income earned during a marriage is considered jointly owned. That means contributions you make to your 401k after you remarry could be considered partially owned by your new spouse. So let's say you work for 5 more years after getting remarried, and during those 5 years, you contribute $60,000 or $70,000 to your retirement account. A portion of that could be legally considered marital property if the marriage ends in divorce. This is exactly why a prenuptial agreement isn't just for the ultra-wealthy. It's a practical financial document that protects both of you. And at James Retires, we'll say it clearly. Getting a prenup before a second marriage isn't a lack of trust. It's a sign of maturity. It's 2 adults who have both been through hard times saying, we love each other and we're going to be smart about this. Let's move on to the second asset, because this one is where emotions really get tangled up with money. Your home. Whether you own it outright or you're still paying a mortgage, your house is probably one of your most valuable assets. And when people remarry, one of the most common decisions they make is adding their new spouse's name to the deed. It feels like the right thing to do. It feels like commitment. It feels like trust. But depending on your situation, especially if you have children from a previous relationship, this decision can have massive unintended consequences. Here's the scenario that plays out in probate courts across the country. A parent owns a home, free and clear. They remarry. They add the new spouse to the deed as a joint tenant with right of survivorship. Then, that parent passes away. By law, the surviving spouse now owns the home entirely. The children from the first marriage get nothing. 0. Even if the parent always intended for the kids to inherit the house someday. Even if there's an old will that says the kids should get it. Because how the deed is structured overrides what the will says. That's the law. And those kids have very little legal recourse. This is a devastating situation that tears families apart, and it's completely preventable with the right planning. One of the solutions is to place the home in a trust before remarrying, specifically what's called a revocable living trust, where you can dictate exactly who gets what, when, and under what conditions. Another option is to work with an estate attorney to structure the property ownership in a way that protects your children's inheritance while still providing security for your new spouse. The point is, do not add anyone's name to your home deed without sitting down with an estate planning attorney first. The cost of that consultation is a few $100s. The cost of not doing it could be your entire family legacy. Now, we're going to pause for just a second because I want you to think about someone you know who's either been through a divorce or is thinking about getting remarried. This information could genuinely change their financial future. So do me a favor, share this video with them. Right now, while you're thinking about it, text it to them, post it, send them the link. You might be doing them the biggest favor of their life. And drop a comment below. Tell me where you're watching from and whether you or someone you know is navigating remarriage and finances. I read every single comment on this channel. Now, let's get into the third asset. And this one is the sneakiest of all three because it doesn't look like an asset at first. It's your estate plan. Your will, your trust documents, your power of attorney, your healthcare directives, the whole package. Most people set up their estate plan once, maybe right after they had kids or bought their first house, and then they never touch it again. When you remarry, your entire estate plan needs to be reviewed and almost certainly rewritten. Here's why this matters so much. In most states, there's something called an elective share, or a spousal inheritance right. This means that if you're married and you pass away, your spouse is legally entitled to a percentage of your estate, typically between 1/3 and 1/2, regardless of what your will says. So even if your will clearly states that everything goes to your adult children, your new spouse can file a legal claim and take a substantial portion. And if you haven't updated your will, and it still references your ex-spouse or old assets, the legal mess that follows could tie up your estate for years, cost your family tens of thousands in legal fees, and leave your loved ones with far less than you intended. The fix here involves several steps that need to happen in coordination. You need a new will that clearly addresses your current situation. You need to review and potentially restructure your trust. You need to make sure your power of attorney names the right person. And you need to actually sit down and have a real, honest conversation with both your new spouse and your adult children about your intentions and how your estate is structured. These conversations are uncomfortable. People don't like talking about death and money at the same time, but families that have these conversations before something happens are the ones that stay together after. Families that avoid them are the ones you read about in headlines about inheritance battles and estranged siblings. Here's something else happening, specifically in 2026, that makes all of this even more urgent. There are ongoing discussions in Congress about changes to estate tax exemptions. The exemptions that were significantly raised under the 2017 tax law are being reviewed, and depending on what happens, the threshold at which estates become taxable could drop dramatically. If your total assets, including retirement accounts, home equity, life insurance payouts, and investments, add up to more than $1 million or $2 million, you could be affected. This is not just a concern for the extremely wealthy anymore. A paid-off home in many parts of the country, plus a solid retirement account, can easily push you into territory where estate planning becomes a tax planning issue, not just a family issue. And if you're remarrying, the way your estate is structured between two people, with combined assets and different children from different relationships, creates a level of complexity that really does require professional guidance. This is not a situation where an online template will protect you. Let me bring this all together, because I want you to walk away from this video with a clear plan of action, not just a list of worries. If you are thinking about remarrying, or if you've already remarried recently and you haven't taken these steps, here is exactly what needs to happen. First, gather every financial account you have and check every single beneficiary designation. Update them immediately. Second, consult a family law attorney and seriously consider a prenuptial agreement, not as a sign of distrust, but as a responsible financial decision. Third, do not make any changes to your home's title or deed without speaking to an estate planning attorney about the best structure for your specific situation. Fourth, have your entire estate plan reviewed and rewritten to reflect your current life, your current spouse, your current family, your current intentions. And fifth, sit down and have the honest, open financial conversations that most couples avoid. Talk about debt. Talk about income. Talk about what you each want to leave behind for your children and grandchildren. At James Retires, we believe that the people who navigate life's biggest transitions with confidence are the ones who get the right information at the right time. You found someone worth loving again. That's not something everyone gets. Protect that relationship and your future by going into it with your eyes open and your financial house in order. If this video helped you or gave you something to think about, please leave a comment below and tell me which of these 3 assets you hadn't thought about before. Your comment helps other people find this video and might just save someone else from a very expensive mistake. And if you haven't already, subscribe to James Retires right now. There are plenty more videos on this channel covering everything from Social Security timing to downsizing your home to making the most of your retirement years. Thank you so much for watching. Take care of yourself, take care of your finances, and I'll see you in the next one.